Hello and welcome to See You in Court, a podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. During each episode, we dive deep into stories, cases, and insights that matter to Georgians. You can learn more on our website at www.seeyouincourtpodcast.org. Join the conversation on our YouTube channel at See You in Court Podcast, and stay connected with us on our Facebook page at facebook.com/See You in Court Podcast. This podcast is sponsored by the Georgia Civil Justice Foundation. Your hosts are Robin Frazer Clark and Lester Tate, who are both past presidents of the State Bar of Georgia and who both serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Frazer Clark, and with us here today is our amazing co-host, Lester Tate. Hey, Lester, how are you?
I'm doing well. How about you?
I'm doing great. My husband and I, Bill, we just celebrated our 33rd anniversary at Lake Oconee for Father's Day.
I saw pictures of you all on the golf course, and I was wondering who won that round.
Oh my gosh, the heat and the mud won the round. It was hot and wet. How are you doing this weekend? For this past weekend, you have a great Father's Day?
I had a great Father's Day. Went and played a little golf myself with my son, and I actually won. I think he probably let me win since it was Father's Day, but it was a good day nonetheless.
Great. Well, today we're excited because we have Atlanta lawyer and a very close friend of both of ours, Joyce Gist Lewis, as our guest today, and we're going to talk about her law practice and her involvement in the State Bar of Georgia. Let me introduce our listeners to Joyce. Joyce Gist Lewis is co-managing partner at the law firm of Krevolin Horst, LLC, where her practice focuses on business litigation and employment law. Joyce's 2 decades of experience include serving as lead counsel for claims involving professional liability, director and officer liability, business divorce, real estate litigation, employment discrimination defense, and catastrophic injury defense. Joyce represents government clients seeking counsel in sensitive interagency disputes and investigations. She also represents political campaigns and voting rights advocates in election law issues. She was named to the short list of nominees recommended by Georgia's Judicial Nominating Commission for appointment to the Georgia Court of Appeals in 2018 and to the Atlanta Judicial Circuit in 2011 and 2012. Joyce has served on the State Bar Board of Governors representing the Atlanta Circuit since 2018 and has served on the Executive Committee of the State Bar since 2024. She was just reelected to the Executive Committee of the State Bar of Georgia, and I had the honor of seconding her nomination. She has served in leadership roles with Lawyers Club of Atlanta, the board of the Federal Defender Program, Inc., the Georgia Association for Women Lawyers, the Board of Visitors for Georgia State University College of Law, and Georgia State University's Bleckley Inn of Court. She is a past recipient of the State Bar's Chief Justice Thomas O. Marshall Professionalism Award and the Atlanta Bar's Outstanding Woman in the Profession Award. Joyce received her BA from Wake Forest University and her Juris Doctor from Georgia State University School of Law in 1999. Joyce, welcome to the show.
Well, thank you both so much for having me, Robin. It's a pleasure to be here.
Great. I'd like to just tell our listeners, have you tell them a little bit, first of all, about just generally how you got involved in law and what made you decide to be a lawyer.
Oh, wow. My dad always wanted me to be a lawyer. I wanted to be an actor. And when I went to college, I remember we're at Wake Forest. I'm a freshman, like literally we're there and we're moving in. And my dad's driving me around the campus and he's like, you need to go over here and check out the law school. And I was like, Daddy, I am 18 years old. I do not need to go and check out the law school. It was very important to him. I think his brother was a lawyer, and I think my dad always wanted to be a lawyer. He was a history teacher. He wound up getting a master's in political science, and he spent most of his career working for what is the South Carolina state equivalent of the EEOC. Right, it was called the State Human Affairs Commission, and so I think he had that ambition for me, and I pushed against it. I got a double major actually in English and theater when I was at Wake Forest, and I moved to Atlanta because I was offered a very competitive internship with the Alliance Theater Company. At that time was being run by Kenny Leon. And so the first 2 years that I was in Atlanta, I was going to acting classes every night. I was one of the people who puts on the daytime shows for the school, when they bring the school kids into the Alliance to see that. I was understudying the main stage productions, doing all that, and just really enjoying the idea of being an actor. Now, this was in 93 to 95. So Atlanta was not quite the hot film and television hub that it is now. So when I finished my internship, I sort of, temping, doing things that were not really engaging all of my brain capacity. And I was feeling that. And I was feeling like I need something that is going to stimulate me. I need something that is going to be interesting, that is going to, really get me, get my cylinders firing. And my husband, then fiance, was already a practicing lawyer, and he would come home at night and tell me about the interesting things he was doing. And I started to think, well, maybe I should apply to law school. And I teased my dad after the fact, because it was like, all I really needed in order to realize that I wanted to go to law school was to get away from my dad pushing me to go to law school. And I think other people, and I tell my husband that now. We have 2 children who are college aged, and I'm like, do not push them, because if you push them, they will react the other way. And Robin, I know you have a daughter who's a lawyer, so I don't know whether you adhered to that or not, but
we did.
But like me, you're like 2 lawyer parents raising a boy and a girl, and the impulse.
You just gotta let them come to it on their own, decide that on their own. Yeah, don't push, because you're exactly right. But yeah, our daughter decided on her own, I'm going to go to law school, and it's perfect for her. She, we're very happy and very proud.
Well,
but just like, my son's an artist, so it's perfect for him too. He would have been a great lawyer too. And just like, Lester's 2 kids, both of them would have been great lawyers, honestly.
It's kind of funny. My son's now gone into commercial real estate, and he never liked the public speaking, part of lawyering, but he likes the kind of negotiating, deal making, part of that. So it's kind of funny. So Joyce, I'm curious, some of the, there's a lot of similarities between acting and lawyering. In fact, you may have gone to the David Bell seminar. It's about lawyers, how to try cases. And he's a theater professor at Duke University. Do you see a lot of similarities between your former profession and your current one?
Yes. And it's interesting, because when people hear what I got my bachelor's in, they're like, oh, that's interesting that you went to law school. And I said, it actually makes perfect sense. Double major in theater and English. So, I love to write. I love to read. I love to get up on my feet in front of people. At least I'm not afraid of doing that. And they mesh really well. The theater part of it, the thing that I actually think gives me a huge leg up with that is, part of what you do in theater is you have to personify someone who is not you. You have to put yourself in the shoes of someone else, and you have to see things through their eyes. And I think that is something that is an especially valuable skill for a lawyer. Our clients come to us and they want our advice. They shouldn't want us to just tell them what they want to hear. They should want us to tell them what the other side of this is going to look like, what the risks are that they are potentially facing. And I will get in there and I will advocate as hard as I can. But I also have always wanted to be the kind of lawyer that is going to tell my client, this is what I'm seeing out there as far as your potential exposure, your downside risk, and this is my advice. Ultimately, it's the client's call, but I think that there is danger when lawyers aren't able to put themselves in the position of the other side and see it from that angle. I think there's danger of being blindsided by outcomes when you do that. But anyway.
But also the art of persuasion in the courtroom, I would think you draw from your acting career quite a bit.
You know, I think so, because I'm not, I mean, I think there are different ways to creatively tell a story, right? As an actor, you trained in memorizing scripts, but you also trained in improv and being able to react to what's happening in the moment. And that is a skill also that I think that lawyers, it's invaluable for lawyers. You guys are both trial lawyers, so I know you have seen this, because I've seen it, where you go into court, whether it's a trial or whether it's a hearing or something, and someone is just like stuck on their script. Like they've got the thing that they were going to read and they are just sticking to that. And you're like, you're missing so many opportunities, right?
Well, yeah, that's not
in
effective.
a book and
That's
let
not
us read it. That's my.
Lester's never stuck to a script in his life.
That's right.
Well, I know you guys haven't, because you're both excellent lawyers. But I mean, not having enough confidence that you know what your case is about, and that you know what the law is, that you can have a conversation with the court, I think is crucial to success in being a lawyer. I was very fortunate that when I was ready to look at going to law school, that there were good options here in Atlanta, because I knew I wanted to stay in Atlanta. And Georgia State, I cannot say enough good things about my alma mater. Great school. I got a scholarship under the Atlanta Law School Fellows, it was called. So I don't know if y'all remember the Atlanta Law School, but it was a school here in the city that apparently went out of business and went defunct long before I started law school. But they had set up fellowships for students at Emory, Georgia State, and Georgia, I think, full tuition fellowships from their endowment. And what an amazing thing to do, to take that endowment money and use it to make sure that other people would be able to pursue careers in the law, even if your law school no longer exists, you're still making it possible for other people to do that. I found that really inspiring. I was very grateful to have that opportunity. And Georgia State, I just had the best experience. Con law was my favorite subject. Eric Siegel was my con law professor.
Oh, and we've had Eric Siegel as a guest on our podcast.
Yeah, we have.
I know you have.
He's great.
He is. He's great. And we, I just had an excellent experience there. So, it was funny when I was about to start law school, my husband's like, "You're going to hate law school." I loved it. I loved being around all of these really smart, inquisitive people. I loved the fact that we were being asked questions every day and that we had to be prepared to answer those questions and to think deeply about, the things that were happening in the cases that we were assigned. I just, my nerd side really enjoyed law school.
That's cool. I did too, actually. I don't know about Lester. Lester was in such a hurry to start practicing. I don't know. I think he finished in 2 years.
I went to law school, I think in Joyce's hometown.
Oh, that's right. You went to Columbia. You went to USC.
That's right. Yeah. If I ever meet an Ivy League snob and they ask me where I went to law school, I say Columbia, which is really true, you know.
Yes. The Columbia.
Where'd you go to law school? Columbia.
That's right.
South Carolina.
But I had a great experience with somebody who Joyce may know, but I got a job my first year, and I worked for a guy named Richard Gergel, who's now a federal judge, when he was in private practice. And he had a practice about like mine now. So it was just like, it's like I've been doing the same thing for over 40 years now, it seems like sometimes, but just in, you know, a little bit different role. Did you ever consider going back to South Carolina?
No. There was a time that I within a few years of me taking the bar and starting to practice, I said to my husband, we need to take the bar in South Carolina in case we ever want to move back. And, you know, life happened and time happened. So we never did. My dad tried to, you know, convince us, but, you know, but I love Atlanta. I love being close enough to my family in South Carolina that if I can hop on I-20, it's a 3-hour drive. I can get there, don't have to get on a plane, but I love everything that this city has to offer. And I really love the legal community here.
You know, I was only first in one thing in my law school class. I was the first to be a lawyer because I took the Georgia bar after my second year. And always like you, I thought, well, I might take that South Carolina bar. But then I was like, no, not going to do it. If they ever get reciprocity, my friend John Few, who's on the South Carolina Supreme Court, I tell him, you get reciprocity for me over there, I'll join, but I ain't taking the test, you know.
They're not going to do reciprocity for the same reason that Florida doesn't do reciprocity, right? Because all these lawyers want to retire to Hilton Head. Retire.
That's very true. Very true. Joyce, let's talk a little bit about your law firm, Krevolin Horst. And I mentioned that, I think I did, that it's now a majority women-owned law firm with 6 of the 7 newest attorneys that were recently added are also amazing women lawyers. And you are responsible for firm ethics, financial reporting and oversight, HR matters, and the leadership of the litigation section of the law firm. That sounds like a pretty big task. First of all, just amazing that it's a women-owned law firm. That is obviously very rare, even though we're in 2025. I think that's probably still pretty rare.
Yeah, I mean, we were looking, we think we might be the largest, if not one of the largest women-owned law firms on the East Coast, actually, not just in Georgia. But it was something actually that was an ambition of mine for a while. I came to Krevolin Horst after I started my career at a mid-sized firm where I, came up the ranks from associate to partner, left there, started my own firm, Shingler Lewis, with my partner, George Shingler, whom you both know. And after 7 years, I came here. And when I came here, the discussion with Jeff Horst was, he was very open with me at the time. He was like, whatever you want to do here, you're going to be able to do. He's like, if you want to be the managing partner of this firm, he's like, we will get you there. And it's funny because I wrote down a long time ago, over 10 years ago, I'm sure, I wrote down an ambition of mine, which was to have the largest woman-owned law firm, in Georgia. And part of the motivation there is I love what I do. And I think it's a shame when people are lawyers and they feel like they can't live their life and enjoy the practice of law. I have seen so many of my peers, and Robin, I'm sure you've seen even more of yours over the years, who have just sort of drifted away, felt like they couldn't really sustain a career in the law. And these are brilliant people, brilliant women, but not just women. There are the next generation of lawyers. One of the things that I really admire about them is that the men want to be, they want to have a life too. They want to, get to see their children as well. They want to, participate in their families. And in the back of my mind, I was always thinking, we can make a place like that. We can make a place where people can do really good work, where they can be incredibly engaged, but they're also not feeling like they have to crank out 2,200 hours,
Right.
billable hours a year, or, slog through work in a place where they don't feel like they can be themselves, like they can bring their whole selves to the workplace. So my partner, Chrissy Wolf, who joined Krevolin the same year as I did, she and I talked very early on about making this a woman-owned firm, probably going back to like 2018, 2019. And we had a lot of the same ambitions in that regard. And Jeff Horst and Doug Krevolin, who are a little older than us, they had the vision and the foresight to know that they wanted this firm to continue into the next generation. And so one of the things that we did within a couple years of me getting here was we developed a strategic plan that included succession planning, a way to transition the traditional managing partner responsibilities on from the original named partners. And they had the model that they had, though, of sharing the responsibilities of managing partner was also a model that we thought would work well for us. The opportunity presented itself towards the end of last year. Allegra Lawrence Hardy, who is an amazing lawyer, and I know y'all are familiar with Allegra, she and her firm were looking to make a transition as well. And sort of, I say the stars sort of aligned for us.
That's cool.
We had a great relationship with Allegra. I had a great relationship with her firm before. She had been a client of mine. She'd been a client of Doug's. And when the opportunity presented itself to come together, the timing was also good and right for us to execute the final phase of the succession plan, wherein the titles actually moved to Chrissy and myself and now Allegra. And we are sharing those responsibilities. It is a lot. I come home and I say to my husband, I'm like, somehow I'm working just as many hours, if not more hours, but my billable hours are a smaller percentage than they used to be of my working time. But I love it. I love the fact that the folks at the firm have trusted us and are excited about this new phase of Krevolin and Horst.
I'll say I am a close friend with Jeff Horst also. You and I and Jeff have served on the executive committee of the Lawyers Club of Atlanta together. And that's really where I got to know Jeff. And he is an absolutely amazing human being. And if there's any lawyer out there besides Lester Tate who would support equality in the practice of law, I would say it's Jeff Horst. He's an incredible friend. And
Jeff and I've had a case going up here with each other. We're on the same side, and it's been a lot of fun going to court with him and everything.
And I noticed, Joyce, that your law firm's website, when I first clicked on it, it says "All Rise."
Yeah,
I love that sentiment.
Thank you. Well, yeah. I mean, you were there's a little bit of Robin Frazer Clark in that sentiment, because when you were president of the state bar, your tagline on your emails always said "A rising tide lifts all boats."
That's right.
And I think that's part of what we're trying to convey there, is that we succeed together. We are a team. I think a lot of people sometimes have the experience of being in a law firm where they feel like not like they're duking it out with their partners, but like they're sort of they're on their own, right? You're all under one masthead, but it's sort of every man or woman for themselves. And one of the things that we have tried to do here is make sure that everyone feels like we have got each other's back. We have each other's back. We also have our clients' backs, right? We develop those relationships. We get to know them. Their successes are our successes, and their failures are our failures. I think that makes us really effective advocates. Just being invested in that way, in both the work that we're doing and also in the firm that we're building. But yeah, I'm glad you noticed that.
Yeah, I loved it. I loved it.
So Joyce, you and I have been involved in a couple of sort of political type cases, voting rights type cases together. How did you get started with that?
So my dad again. I mentioned that he worked for the South Carolina equivalent of EEOC for many years, but I didn't mention that the person that he worked under was a gentleman named Jim Clyburn, who is the former House Minority Whip in Congress, longtime Democratic congressman. So my first intro into politics was, as a teen or preteen, my dad sending us out to hand out flyers for Jim Clyburn when he was running for office. And my family has just always been very politically engaged. It was taught to us very early on that it is important to vote. It is important to exercise this right that so many people, especially in places like South Carolina and Georgia, have fought and died for. And we have been taught that is your voice, right? And I'm a lawyer, so being the voice for someone is really important for me. But voting is the opportunity for everyone to have their voice heard. And so when I came to Krevolin Horst, my partner Adam Sparks had already started doing some work in the election law arena, and that opened the door for me to really get involved in these kinds of cases. I think the case that you and I had together, Lester, was the one about the Supreme Court seat.
It was, yeah,
and about
versus Raffensperger.
Yeah, so that case was about whether or not a sitting justice could essentially cancel an election that was upcoming, that he was going to have to be in by quote unquote resigning, and yeah, that was a really interesting case. And
a lot of our prophecies proved to be true. We didn't win that case, but a lot of about how that would be used, turned out to be spot on, in the long run.
Well, right. And I think one of the prophecies about that case was, be careful what you wish for, because if we're going to make it so that the only way that people can get on the court is by running against incumbents, people are going to run against incumbents.
Yeah.
Right.
Yeah. Well, you mentioned your partner, Adam Sparks, and I read an article you and Adam published together, a law review article called "In Defense of the Foundation Stone, Deterring Post-Election Abuse of the Legal Process." I really enjoyed reading that. It's about, it is still, okay, it was published in 2021, and it's still very timely right this minute. I think we're going through exactly what we were going through 5 years ago. So very interesting article. Talk to us a little bit about that, the main thesis of it, of post-election sort of abusive lawsuits to say an election was not valid, and trying to take away the vote that you say was so important growing up in your family, and how you were taught that it's so important. But these lawsuits are trying to really dilute voting and taking away the right to vote.
Yeah. So the main crux of that particular article, was in 2021. Obviously, we had just had something pretty exciting, not exciting in a good way, happen on January 6th of 2021. And that was sort of the natural, in my view, outcome of all of the refusal to accept the the outcome of the election, right? What the article is about is the role that lawyers played and play in making sure that our constitutional norms are being observed and honored. Adam and I had talked about, we had been reached out to by UGA, as they saw that we were doing a lot of work in the election law space in that time period between Election Day in 2020 and the certification, or even after the certification, the challenges kept coming, actually. But they invited us to write a piece, and the contribution that we thought we could make was our observation that a lot of what was happening could not have happened without lawyers being willing to bring some of these frivolous. and spurious claims in court, being willing to sign their names to it. And what was really sort of galling during that time was the notion that every time one of these got filed, wherever they were being filed, and they were being filed all over the country, and many of them were being filed in Georgia, but every time one of these lawsuits got filed, trying to get courts to throw out votes, trying to get courts to refuse to certify election results, every single time a court said, no, we're not doing this. We're not disenfranchising tens of thousands or hundreds of thousands of people on no evidence. No. And then somebody else would file basically the same lawsuit, or the same lawyer would file basically the same lawsuit, which, it's sort of unfathomable to me as a civil litigator. If I go into court and I file something and a judge tells me no, and tells me no in no uncertain terms, this is not the case, and then I go and file the same thing again. I mean, I'm already on notice, right? When we sign pleadings, we have a responsibility. There can be, and certainly there are often circumstances where there's a good faith argument that that you're trying to challenge a law that currently exists, or you're trying to make new law. There's room for that, but not with what we were seeing in late 2020 and early 2021. I mean, the only reason that those lawsuits, again, this is talked about in the article, really the only reason that those lawsuits continued to be filed was so that the people who were behind them could say to their constituents, oh, look, something must be wrong because there's a lawsuit. Oh, look, here's the proof that there was, illegal voting, or, because there's a lawsuit pending. So clearly there must be some legitimacy to this claim. And they essentially took tried to take a patina of legitimacy from the courts, just by virtue of filing the lawsuits. And the notion that lawyers would be involved in trying to do something that is taking away these very fundamental rights from people is, it's disturbing. And obviously, I mean, we also talk in there about Shelby County, and about the fact that, we are in this time period now where it feels like a lot of the rights that were fought for leading up to and through the civil rights movement are being rolled back. And we as lawyers we have an obligation. I mean, our first obligation is not just to sign our names to anything that a client is going to pay us to sign our names to. Our first obligation is to the Constitution of the United States, Constitution of Georgia, and our duty as officers of the court. Just because someone is going to pay my bill does not mean that they get to co-opt my character in that way.
So I'm curious if you, as you look at that, you're certainly just talking about elections, but there's so many areas today that when a member of the public, they read a news article about a particular case, and some of these are trials, like Karen Reed, has been a widely publicized criminal trial, in Massachusetts. But people read, they think 2 minutes on Google is the equivalent to having heard all the evidence, read all the briefs, being educated in a way to understand the law. And what they really don't like is, I just don't like the decision. I don't like the outcome, regardless of what the basis, for that is. And I thought it was interesting that you mentioned January 6th, because, when people talk about the rule of law, I sort of see that as being the antidote to violence. You don't go over and beat your neighbor up if he puts his fence on your property because you got another recourse. But do you think there's a wider implication to this? The courts are ineffectual. And in other words, we're going to file a lawsuit and lose it, and it's going to help folks that agree with us. It's going to destroy their confidence in the courts.
Well, right. It's sort of like the whole deep state thing, right? I mean, you're advancing this narrative that it must be corrupt because it ruled against me, right? And I don't think that is by accident. I do think that a lot of what is happening is intentional. I am encouraged to hear people, including our Georgia Supreme Court now Chief Justice Nels Peterson, came to the bar meeting that Robin and I were at a few weeks ago, and reaffirmed the commitment to the rule of law, and actually had all of the lawyers who were present in the audience stand up and have had all of us raise our hands and reaffirm our commitment. If you study history, which I do not pretend to be a history scholar, but I mean, this is how civilizations, this is how societies are undermined in certain circumstances, where you take out, you take away the history, you take away the rule of law, you take away people's feeling that they have a redress that moves beyond, who they know or how much money that they have. And that society collapses. And I hope that we are not, there. I do believe one of the things that we talked about in the law review article was an anecdote from Judge Phipps, whom you both know. Judge Herb Phipps from the Georgia Court of Appeals. He would tell this story about growing up in Southwest Georgia,
Baker County.
And he would tell this story about how, as a young person, he went to court and saw, a judge knowingly disregard the law, and admit that he was disregarding it because he, quote, I have to live in this little town. And I think there's a lot of that, Lester, going on right now. I think there's a lot of, and I think this is part of what's going on with Congress, frankly, not to get too much into politics stuff, but I think people are making calculations based upon what's going to be good for them, as opposed to what's going to be good for the law. And it has been incredibly encouraging to see that our judiciary has not been doing that the judges, for the most part, have been adhering to their duties, adhering to an analysis that, that answers only to the rule of law, and not to the idea that they're going to be under some sort of threat or harassment or, removal from office for doing the right thing. So, I hope that continues. I hope that the law firms that are standing up to the actions of the administration, which are attempting to get them to disregard their duties and their oaths, and instead pledge fealty to to an administration, as opposed to, doing what their conscience tells them, doing what the law tells them, and doing what is in the best interest of our profession. I've got a great deal of admiration for the firms that are standing up. I'm proud to say my firm is one of the firms that is standing up. But yeah, it's a very interesting time to be practicing law in America.
In your law review article about many of these lawsuits trying to undo elections, you cite numerous complaints, lawsuits filed. And I noticed that many of the lawyers who filed them have now been disbarred, whatever state they may have been barred in. One, which I'm actually very glad to see, because it's exactly what you're saying, Joyce, that they lost their duty to candor. They lost their sense of oath to the rule of law by doing it. One lawsuit you cite, the lawyer who filed it has now been disbarred, and he even put in his complaint, and he talks about Dominion voting machines, that they were corrupt because they also helped make sure Venezuelan dictator Hugo Chavez never lost another election. I had to laugh out loud at that one. I couldn't believe that was actually in a complaint, but you cited in your...
It was wild. It was wild times right there, right after the 2020 election. I mean, there was a lot of stuff flying around that I would be surprised if these people would claim it now.
Crazy. Let me ask you, we're talking about the current federal administration threatening lawyers, trying to intimidate lawyers. You do election law, and I'm wondering, do you ever have to think about that? Like, hey, if we take on this client, we may have retribution, or they may try to intimidate us. Do you ever have those thoughts, or you just say, heck no, we're going to take this case on?
No, we're gonna be guided by our own judgment, and we're not going to be swayed by threats, real or implied, because if we lose the rule of law, and I've been saying this a lot to people lately, if we lose the rule of law, what are we here for? What do people need us for? What do people need lawyers for? If there's no rule of law, if it's really about who's got the most money, who's got the most influence, if that's all that matters at the end of the day, then they don't need us anymore. Right?
And how are we still America? I mean, that's how our country was founded.
Yeah.
Based on the rule of law. It's just mind-boggling to me, but thank you for what you're doing, and keep it up. I'll say that because I think you've got more clients coming with the current administration.
It's been very interesting, because a number of the cases that we've been involved in, the United States would intervene. Like, the U.S. attorneys would intervene and be advocating for the same side as us on the voting rights side, on the access to justice side. And what we've seen in the past several months is them withdrawing, or
and not taking a position, or taking on the other side,
like withdrawing, just withdrawing the intervener complaint, or just moving to dismiss the intervention and just stepping away. And obviously there's been more in the news about that as well, but it's sobering.
Yeah, I'm curious that, there were a number of law firms that through the law firm intimidation orders sort of bent the knee and, went and entered in these agreements, which in my view may well not be enforceable anyway. But in any event, the interesting thing to me is that for clients, if a lawyer that won't speak truth to power is a dog that won't hunt, I mean,
if you're not going to speak up for yourself,
I don't understand how clients would sort of stay with somebody that would just roll over for that.
if you're not gonna advocate for yourself and for your firm and for your profession, why would a client think that you're going to advocate for them? Why would they believe that you're going to go to the mat for them if you won't even go to the mat for yourself?
Good question. And I think the ones that rolled over are now, I think, paying for it. We've seen partners leaving those firms, and I think clients have left those firms.
I'm gonna jump a little bit ahead because this is my news item for the end. But the American Bar Association has now filed suit on behalf of the association and using their associational membership to bar those orders generally, not just against a law firm. And that's when the last day that they've done that. And I'm proud. I wasn't with y'all in
Sawgrass.
It's Sawgrass because I was at the American Bar Association Board of Governors meeting. But I'm proud of the association for doing that because there are a lot of firms that could have been targeted with that maybe didn't have the ability, really the firepower to stand up to it, and so hopefully a favorable ruling will be forthcoming on that.
Well, on that point, Lester, there have been rulings on, all of the law firms that were targeted with executive orders that have gone in front of a judge, the judge has invalidated the orders. But I think the fact that these other big law firms still feel like they need to play ball, if you will, is a reflection of a lack of confidence in the enforceability maybe of what these judges are. So the judge says that's invalid. You don't, stop doing that, United States. Mm-hmm. And the United States kind of shrugs its shoulders and says, maybe I will. Maybe I won't. I think
there's a school of thought. Nobody ever thought they were going to be enforceable. They just wanted to, it's an intimidation tactic, really.
Well, and it speaks to this idea that is happening now where it's not really important about whether what you're doing is legal or enforceable. All that's important is the headline, because that's all that people are, that's all people are getting, right? They see a headline that says, that there's an action that's been taken against Harvard. They don't pay attention to whether or not that's actually something that can be followed through upon. And it is creating this atmosphere of fear and chilling of expression.
So an interesting question, and I'd love to hear your view on this, Joyce, but, we have for years and years and years, you've heard the expression, freedom isn't free. It's something you got to go out and fight for. And so while I very much sort of decry these tactics, these intimidation tactics, I wonder if we're not also just finally having to kind of fight for that freedom a little bit. We're kind of realizing it really isn't free, and it has been free for a long, long time.
Well, it hasn't been free for everybody, Lester.
Right.
Right. And that's the thing. There are large swaths of America where people had to do all of this for years. I mentioned Judge Phipps before. The reason he tells that story is because his community was not getting the benefit of the rule of law. Right.
Well,
and I think
it's also, if you go back to Judge Phipps, he went to Case Western Law School because University of Georgia Law School would not admit an African American.
Absolutely. And he's
just an amazing person.
He is. He's a civil rights hero. But I make that point, Lester, to say I do think that this is a reckoning in a way with the fact that freedom isn't free. But what's interesting about it is in the 60s, it felt like there was a group of people for whom that was an issue they were having to fight, and now I think it's wider, right? I think people are realizing that the color of your skin is not necessarily going to guarantee you that you are going to get due process.
Right.
It's now more about fealty, if you will.
Well, don't you also think that it's because for the first time in American history, we have a president who does not only doesn't respect the rule of law, but I'm not even sure knows what it means.
I don't know that he's the first.
Well,
but
I mean, even Richard Nixon resigned,
it's here's the thing. We have elections. And I will stand up and fight every day for the right of people to be able to go to the polls and exercise their voice in that way. I think the challenge that we as a society have is breaking through the noise and breaking through the tendency that a lot of people have to just focus on the surface noise of what they're hearing about politics, and to decide, I want to change, but not really think through what that is going to look like or manifest in. We got to figure out a way to make sure that when people are voting, that everyone that is eligible to vote gets to vote and is not barred from doing that by these artificial barriers that it seems like just keep popping up in the wake of Shelby County. And B, making sure that we educate our children and the population at large about how important it is to be thoughtful in making that vote and not to be voting out of, I'm mad because of how much eggs cost, or, I want things to be different, so I'm going to pick a different person. Because, no one can say that they didn't know what, no one can really say that they didn't know what this president was going to do.
So true. Did you want to say something else on that, Lester?
One of the things that I was going to sort of bring up is I think a lot of that, and I think this is true with the judicial stuff too, is there's a lot of sort of what I would call herding. We really don't take the time to learn about each issue on our own, like, whether it's, why student loans are important, why Medicare is important, why gas or eggs does cost too much, that kind of thing. We just sort of go with the herd and with sort of a feeling that it will be that way. And, when you look at the people, and I'm sure I haven't had a chance, I need to go read your article, but, know it, kind of being close enough to remember and be involved in some of that. The judges that were rejecting that were appointed by a Democratic president or a Republican president, or in state courts, maybe a Republican governor or Democratic governor, or they ran on one ticket or another, but they pretty uniformly stood. They took the time to look at each one of those individual issues, to reach a conclusion about it, not just a shot from the hip. And I don't know what we do about that with public education. You, Joyce, you talk about, and James Clyburn, is legendary in South Carolina. For those that don't know, he's either the John Lewis of South Carolina or John Lewis was the Jim Clyburn of Georgia. He's that kind of figure. And so, learning at his feet was just I'm sure a great education. But we have people that, don't even know they don't even know what the Congress and the president does now, much less the judicial branch, which gets less publicity in a lot of ways.
Yeah, and I'm very proud of our judicial branch. Like I said, I think if nothing else, that people there is awareness now. There's more awareness, I think, as these orders have been enjoined and the courts have been saying no out loud. And the newspapers have been covering that. I do think that there are people who are realizing how important it is that we do have these three co-equal branches. But there's a large percentage of our population that doesn't, that doesn't know.
I want to switch gears a little bit, Joyce, because I want us to talk just a little bit about this landmark case of yours, what we call the Loudermilk case, which to say it's just one case, I guess that it went on appeal numerous times and back and forth, and but I believe it was a landmark case because it really it said this is what apportionment of damages are in Georgia from the Georgia Supreme Court on a certified court or two certified questions from a federal district court.
Well, actually, from the 11th Circuit.
Oh, from the 11th Circuit. Okay.
Yeah. There was one from the district court earlier. So the
Judge Thrash, right?
Judge Thrash certified a question on the business judgment rule. Okay. And after the trial, the directors and officers appealed, and the 11th Circuit certified a question to the Supreme Court on the apportionment issue. So, yeah, it's got a long history. It's
got a long history, a landmark case. I want you to talk a little bit about it. But first, I'll just say I love it when a federal appellate court, one step below the United States Supreme Court, has to ask our Georgia Supreme Court, what's the answer? and whatever the Georgia Supreme Court says, that's it. Yeah. I love that about certified questions. But tell our listeners a little bit about this really landmark, huge case. Who did you represent, and what was it about?
So I represented the FDIC as receiver for Buckhead Community Bank. So whenever a bank fails in the United States, the FDIC is appointed receiver, and it essentially steps into the shoes of the failed bank. And as the receiver, it has the right to pursue claims of professional liability against anyone that they think may have caused or contributed to the failure of the bank. And I did this work for a number of years, starting in around 2009, right sort of in the heat of the bank failure and financial crisis.
Yes.
Right. And a lot of these cases got resolved before they went to trial. This one could not get resolved. And so we wound up taking it to trial. And I think it was the first community bank case to go to trial on these D&O claims. It might have been the first one to go to trial in the United States.
I think you may be right about that. Yeah.
There had been the IndyMac case in California that they went to trial before we did. But we went to trial in 2016, representing FDIC as receiver. On the other side were the directors and officers of the failed bank, Mr. Loudermilk. Since you referenced that, the name of the case, he was the chair of the board of the bank, and the claim was that the loan committee of the bank, which included all of these folks who were on the bank's board, that they were negligent in approving these commercial real estate loans, development loans, and our position was that they were essentially approving millions of dollars of loans without actually checking to make sure that the borrowers had the wherewithal to pay them back. And our theme going into the trial was that these folks were gambling with other people's money, right? Because they knew that if things worked out for them, if they got, they wanted to build a $1 billion bank essentially. And so they were incentivized to make these loans. And then eventually they were going to potentially sell the bank. And then the directors were going to enjoy all of these profits. So they were trying to make as many of these loans as they could from our perspective. And they were in such a hurry to do it that they didn't really worry about whether or not they could be repaid. They got an appraisal. The appraisal said, 75% loan to value, and they made the loan. Obviously, as we all know now from, on this side of the financial crisis, that did not turn out to be a good move. But all of the banks that are FDIC insured in the country are subject to rules and regulations about what they have to do in making loans. And what we pointed out to the jury was that these directors and officers weren't paying attention to those rules and those guidelines. They were just sort of rubber stamping and, again, looking after their own interest. And the reason we said that they were gambling with other people's money is because the bank's FDIC insured, right? So if they were wrong and the bank failed, it wouldn't come out of the money wouldn't come out of their pocket. The money would come out of the depositor's pocket. And then in turn, the FDIC would have to cover those deposits. And we tried the case for, I think, 8 or 9 days in front of Judge Thrash in the Northern District of Georgia. And we got a verdict in our favor for almost exactly $5 million that we were able to recover for the deposit insurance fund. After the case ended, the directors and officers filed an appeal to the 11th Circuit, and one of the things that they raised in the appeal was that they claimed that the district judge had erred because he had refused to give an apportionment instruction to the jury, and we opposed an apportionment instruction, but their position was that post 2005 tort reform, that there was no more joint and several liability for torts in Georgia. That was the position. The position was, if you've got multiple defendants, you have to have apportionment, and that's that. Joint and several does not exist. Our position was, well, no, there's not actually a case that says that joint and several doesn't exist anymore. And furthermore, you, directors and officers, didn't actually present any evidence from which a jury could apportion fault between you. They were all represented by the same law firm. They didn't put anything.
That's interesting.
Well,
and they were all collective decisions too.
Well, right.
I was going to say they all acted together and made the same decision, right?
Well, and this was the thing. This was unique facts that and then they testified to this, that their rule was that if they were approved a loan, it had to be unanimous. So anybody that was there, if anyone there said no, the loan wouldn't get made. So every loan that we were talking about had to have been approved by them collectively. So, and that was an undisputed fact in the case. They're all represented by the same lawyer. They didn't present any evidence to the jury that would allow the jury to say, well, this director is liable, but that director is not. And so they appealed, and we got to the 11th Circuit, and they made the argument that, that joint and several had been eliminated in 2005. And that was the question that the 11th Circuit then certified to Georgia Supreme Court, asking whether there are any circumstances under which you could, in fact, still have joint and several liability. And the answer, according to the Georgia Supreme Court, was yes.
Yes.
You can. And I think that you say it's a landmark decision. I do think it's a very important decision, because I don't think that the Directors and Officers Council in the Loudermilk case were alone in thinking that. But this case was very uniquely positioned to make that clear. The Supreme Court actually, they answered the certified question, which essentially was, yes, there can be joint and several liability under certain circumstances, which includes a circumstance of concerted action, which Lester just mentioned.
I assume, too, that, and as you know, I had a little involvement with some of those. And most of the time they were covered by an insurance policy. There's a D&O, insurance policy there. And I think it's kind of funny. I assume the insurance policy, the insurer made the decision to go with a singular defense, and then complained that, it wasn't apportioned.
I do not know the answer to that question, Lester. I do not know who made the decision, but
But makes sense.
But that definitely was, that was that was part of the issue, and the district court pointed it out, and then after the certified question came back, the 11th Circuit, in their opinion, pointed out that would seem to be a problem.
And I assume too that that said insurer, assuming it existed, would have howled if you had said the policy limits apply individually to the individually apportioned against defendants too.
Yes, I assume that.
Yeah, and I know the apportionment statutes have changed since this opinion, but it's certainly I do believe there are still attorneys arguing the Loudermilk case to say we still have joint and several in certain situations, regardless of any new apportionment statutes. Still alive.
No, it's still good law, and I think it still applies. The circumstances, are going to be determinative.
Right. Well, I know I think we were on the executive committee of Lawyers Club when you were handling that case, and I lived a little bit of it with you. I remember when you got the verdict, like, oh my gosh, awesome. So I wanted to talk about that because that, in a career to have that kind of case that so many appeals and you lived it for so long. I mean, no telling how long that whole case lasted. Years, I'm sure.
Yeah. Years.
Just wanted to talk about it. Let's talk a little bit about your involvement in the state bar. I mentioned that you just recently won re-election to the executive committee. You've been on the board of governors. Of course, Lester and I are past presidents, so we know your path. Tell us about why you think it's important for you to be so involved, because that's a lot of volunteer time. I mean, you don't get paid for that. You're doing it because of your love of the law, your love of the profession, your love of the State Bar of Georgia. It's a lot, it's a lot of big time commitment.
Yeah, I mean, I as I said earlier, I do love the profession. I love what I do. I want other people to love what they do. I want lawyers to feel the weight of the privilege and the responsibility that is laid on our shoulders to be practitioners. I also want to make sure that we are protecting the interests of the people that we are supposed to be serving. So the State Bar does a number of pretty amazing things. One of the things that I've been involved in most recently is initiative with the Wellness Institute, and Rob and I lay a lot of thanks and applause at your feet, because I think you were one of the people who really spearheaded this need for awareness of the dangers that present themselves to people practicing this profession. We lead all of the professions in suicide. We lead all of the professions in alcoholism. We lead all of the professions in anxiety and depression. And I mean, and these are not things that anybody wants us to be number one at. And we are. I think service in the bar is a great way for us to make our fellow lawyers aware of the community that surrounds us, of the fact that we're not alone in this, and that we have a collective responsibility to each other and to our clients and to the courts to protect this thing, to protect this democracy that we have, to protect this rule of law that we have, because it is not something that is going to protect itself. And I've been very grateful to have the opportunity to learn more of the ins and outs of the bar as I've served on the executive committee. So my first year on the executive committee, I started serving on committees that I didn't really even know existed, but who are sort of behind the scenes doing the work, like the member benefits committee, the insurance committee, the unified bar. These are the committees that are helping keep things running, keep us serving our fellow attorneys. And I do find it really gratifying. I also find it gratifying just to be part of that community when we come together in meetings and we talk to each other about the issues that are presenting. I'm y'all know this, I'm very much a people person. And I think that we would have a much stronger society and we would have a much stronger profession if people were interacting with each other in person, getting to know each other rather than, hiding behind computer keyboards and, and nasty gram emails. I mean,
yeah, I agree. And I'll say that at our Ponte Vedra meeting, State Bar annual meeting just a couple of weeks ago, you mentioned Chief Justice Nels Peterson giving us the oath again. We took renewed our oath to the constitutions. Doesn't really surprise me that just Chief Justice Peterson would do that, knowing the kind of person he is. He's been a guest on our podcast as well, and I know he respects the rule of law. So I really was not. I was glad. I wasn't shocked. I wasn't surprised. It's exactly what the chief would do. How about what do you see? You have some goals in your work with State Bar, or what do you see in the future for the State Bar?
Well, I see several things. One of the things that I see is that there is a small movement of folks who are, trying to potentially do away with the bar. In other states, I mean, you all have heard about Keller for forever, the Keller decision. But in our state too, this past session, there was some legislation that was being floated about disorganizing the bar.
Like you mean like another threat or intimidation tactic?
Well, I don't want to say that, but
okay.
I will say
I'll say it. You don't have to say it. I'll say it.
But I will say that there are people who don't like the idea of their of being part of that community, of having to be a member of the bar in order to practice law. I mean, our bar has not been Georgia's bar has not been in existence relatively, long.
Right.
You and I are both past presidents of the Lawyers Club, and we know that one of the reasons that the Lawyers Club actually came into existence is because there was no bar in Georgia, right? And part of the reason the Lawyers Club arrived was because there were a group of lawyers who wanted there to be professional standards that are enforced. And that's really the most important role of the bar is, in my view, is making sure that people who have this title are not abusing it and are not using it to disadvantage those that they should be serving and helping.
Yeah, so the Florida bar the other day, the Florida bar has been threatening to withdraw from the ABA House of Delegates, and they narrowly voted not to. And then the Supreme Court of Florida said, "Yeah, we're going to make you withdraw from the ABA House of Delegates." And my position, sort of as a member of the Board of Governors, has been, okay, we'll go get other lawyers from Florida to represent you, because they weren't paying any money. They weren't using any money. I was in the House of Delegates. I was a state bar delegate for years. I paid my own way, paid my own hotel bill, the whole thing. I felt like I could vote and do how I wanted to. But you are seeing, I think, encroachment upon the leadership from two distinct places. One is from a small minority that says, I just don't want to be affiliated with anything that says X. And, I can't think of a group that I'm a member of that I don't disagree with something, that's about that, even we get to Lawyers Club. I wish they had a different brand of bourbon sometimes, it's not always, 100%. The other thing, though, too, which I think is a real danger, and I'd love to hear any thoughts you have on this, is what happened in Florida with the Supreme Court, which is, you are an arm of the court, but it's really a lawyers' organization. And to try to cram down on them something that they didn't vote for, albeit a close vote, seems to be sort of an abuse of that. But from both sides, it's an attack on the independence of bar leadership, in my opinion.
No, I agree with that. And I do not feel like we have. I do not feel like we have that threat here. I think there's a good, respectful relationship between the Supreme Court justices, many of whom, I think almost all of whom, were at the bar meeting a couple weeks ago, and the bar. The lines of communication there are definitely open. So I thankfully do not see us as facing that particular danger.
Good.
How about, Joyce, your thoughts on professionalism in the bar? Are we headed in the right direction with that, or wrong direction, or is there something the state bar can do?
I mean, I again, this kind of goes back to the law review article, right?
Yeah.
At the end of the day, if you are being faithful to what you pledged, then you would be treating your peers with civility. You would be, making sure that your cases are being handled responsibly. You would be communicating with your clients, and the bar is there to regulate certain things. The rest of it is really up to us as sort of big boys and girls who have taken that oath, taken that pledge. It's up to us to live that out. I do think, and I do bristle a little bit when those tactics, when lack of professionalism appears to be, at least in the short term, rewarded in some way. That makes me a little concerned that sometimes there are lawyers who think that the way to win is to be as nasty as possible and as difficult as possible and as close to the line as possible. And it feels very transactional. It feels like a very sort of short-term focus on a particular outcome, rather than a focus that is geared towards maintaining the honor, frankly, of the profession.
I totally agree. Joyce, we've enjoyed our time with you today. We ask every guest our last question, and that is, how do you define justice? What does it mean to you?
So you told me ahead of time you're going to ask me this.
Yes, so I know you've been thinking about it.
So I did give it some thought, and really, to me, justice is a combination of access, so the right to be heard, and objective accountability, which I would think of as the right to hold other people to a standard rather than having a decision that's made based upon an arbitrary or a biased basis, right? And that standard can come from the Constitution, it can come from statutes, it can come from case law. And we, as to Lester's earlier point, we as lawyers may disagree on the outcome, on whether the outcome was right. But if the rules have been followed, and if the decision is well informed, then I think that's justice. It may not be what I want, but I can't say that justice hasn't been served under that circumstance.
Great answer.
Yeah. Well, thank you, Joyce. Again, we've been talking with Atlanta attorney Joyce Gist Lewis of the Krevolin Horst law firm. You can find out more about Joyce on her firm's website, which is khlawfirm.com. Thank you, Joyce.
Thank you. Joyce. Thank you, guys. Have a great one.
Okay, folks, now's the time when Lester and I like to share some little tidbit of law-related news that we've seen recently in the news. And Lester, you're up.
Yeah, from the New York Times, June 16th, yesterday, The headline reads, American Bar Association sues Trump administration. A lawsuit by the lawyers group seeks to stop the president's efforts to punish law firms. And as I think most of our listeners know, there were a bunch of executive orders that were issued against a particular law firm. As far as I know, Robin Frazer Clark, attorney at law, and Aiken and Tate with Lester Tate were not amongst those, but these are usually big law firms. And then some would go in and negotiate deals that, to do millions of dollars worth of pro bono work. And so the American Bar Association, which, full disclaimer, I am a member and a member of the American Bar Association's Board of Governors, which is the largest national organization of lawyers, sued the Trump administration on Monday over its efforts to punish law firms it does not like, asking courts to stop the president's campaign against their profession. And of course, in these executive orders were prohibitions from being in government buildings, getting security clearances, other things that sort of made the practice very impractical. I'm going to read the quote from my friend Bill Bay, who is the president of the American Bar Association. He says the administration's intimidation of lawyers and law firms has gone on long enough and needs to stop immediately. While some firms are now protected by specific orders, there's thousands of lawyers who are not party to those cases and do not have the resources to withstand that intimidation, and we're standing up for them. Now, I will tell you, as a member of the American Bar Association, having still served in the House of Delegates and on the Board of Governors, I hear a lot of lawyers disagree with different stands that the American Bar Association takes. I don't agree with every stand the American Bar Association takes, but I think this is one in which certainly all members of the legal profession and those who are legally adjacent professions should celebrate, because I think it is a triumph for the rule of law. There's a great quote by Thomas Erskine, who was a British barrister that I'm very fond of, that says, when the day comes when a barrister cannot stand up against the power of the government, then our liberties are at their end. And I think this is a great step.
Totally agree. And for once, our news articles we selected are the same article, because I was so happy to see this yesterday. I'm a member of the ABA. First of all, just thank you for all your time, as Cliff Frazier would say, your time in the barrel with the ABA on the Board of Governors, and just appreciate that. But I get so upset about when something like this happens, and the only thing that happens are somebody says, I condemn that, without any action. I get really tired of that. So I was so glad to see a professional association I'm associated with, I'm a member of, actually took action. And I haven't read the whole complaint yet. It's 278 paragraphs. But I did want to share one paragraph. Then they call it the law firm intimidation policy of the administration, exactly what we were talking about with Joyce.
Right.
This threatening anybody who dares to say anything against the administration or represent someone. One of the firms, the very first firms that had the executive order, was the firm that represented Hillary Clinton. So it's all about intimidation and retribution. And this one paragraph in the complaint by the ABA says, the longer the law firm intimidation policy and the resulting coercion and submission persist, the more it will be normalized in our legal system. Whoever wins the next election will be free to squelch dissent based on policy disagreements. There's no limiting principle. The next administration might threaten adverse executive branch actions against any lawyer or any law firm that dares to represent an oil company or a gun manufacturer or the Federalist Society or Fox News.
Yep.
And that's exactly right. And we've got to stop it. We've got to stop it. It can't go on. And so I was really, really happy to see the ABA actually take action, not just condemn it. So
yes,
hats off to the ABA.
Condemnation is cheap. It takes some action to do it, and so we'll look forward to how the government responds to that.
Yes, we'll definitely
Hopefully
be
keep our listeners
watching.
apprised of it.
Yeah, filed in the United States District Court for the District of Columbia. So yeah, we'll keep watching that. But first step, we got the complaint filed. Way to go, ABA! So
That's right. That's right. Well, great show today, Robin.
Yeah, great show. And remember, just want to thank our sponsor, the Georgia Civil Justice System, and thank our producer, Philip Hoover, and thank our listeners for listening. And also check us out on our YouTube channel. You can learn more about Lester at aikentate.com and more about me at gatriallawyers.net. So thank you for listening. And until next time, Lester,
we'll see you in court.
See you in court.
You've been listening to the See You in Court podcast, brought to you by the Georgia Civil Justice Foundation. Remember, justice is a shared journey, and your engagement makes all the difference. For further insight and resources, visit our website at www.seeyouincourtpodcast.org. Subscribe to our YouTube channel at See You in Court Podcast for additional content. And don't forget to engage with our community on facebook.com/See You in Court Podcast. Special thanks to our producer, Philip Hoover. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at www.fairplay.org. Until next time, we'll see you in court.